A very good evening to all of you, friends. A very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. So, friends, today we begin with the weekly legal affairs for the month of February, part 11 for the year 2023. In this particular session, we shall bring to you certain very important legal developments that have taken place in the last couple of days back. So guys, let's begin. But before we begin, BYJU'S Exam Prep brings to you a scholarship test on 5th of March at 11 a.m. Get up to 90% scholarship on our preparation program. So guys, let's begin. The Supreme Court has granted an interim relief to Congressman Pawan Khera, who was arrested by the Assam police over his comment about Prime Minister Narendra Modi. Now, Mr. Pawan Khera, who happens to be the spokesperson of the Indian National Congress, was arrested by the Assam police when he was about to board a flight from the Delhi airport. The Assam police came to Delhi and he was deplaned. That is, Mr. Pawan Khera was deplaned because there were many FIRs that were filed across India under various sections or provisions of the Indian Penal Code. So what did Mr. Pawan Khera say? Mr. Pawan Khera, while addressing a press conference, referred to Honorable Prime Minister Narendra Modi as Narendra Gautam Das Modi. Now, on the contrary, the real name of our Honorable Prime Minister happens to be Narendra Damodar Das Modi. Now, there might be a slip of the tongue by the spokesperson of the Indian National Congress, Mr. Pawan Khera, and owing to which various FIRs were filed across India, like Lucknow, Varanasi, as well as in Assam. Now, owing to this, a petition was filed under Article 32 of the Indian Constitution before the Supreme Court by Mr. Pawan Khera, asking the Supreme Court to club all the FIRs to one jurisdiction. So, since while he was addressing a press conference, he had used certain objectionable words, he referred to the Honorable Prime Minister of India, Mr. Narendra Modi, as Narendra Gautam Das Modi, whereas the Prime Minister's real name happens to be Narendra Damodar Das Modi. So it might be a slip of the tongue, but whatever it is, various FIRs came to be filed across India owing to that slip of the tongue. Now, the Assam police came to the Supreme Court and said that Mr. Pawan Khera has deliberately and it was a calculative insult to the Prime Minister of the country. Now, to which the Supreme Court, the Honorable Chief Justice of India, was really astonished and said that how can such a statement attract all these sections? Very well, the Supreme Court said that definitely we are issuing notice, we are entertaining the petition on the issue whether all the FIRs which have been filed across India should be clubbed together or not. Furthermore, the Supreme Court granted interim relief in the form of interim bail to Mr. Pawan Khera. So, if you read the order of the Honorable Supreme Court, it said that in order to enable Mr. Pawan Khera, the petitioner, to apply for regular bail before the jurisdictional court upon the FIRs being transferred to one jurisdiction, we direct that the petitioner shall be released on interim bail. So an interim bail was granted to the Congress spokesperson for having allegedly made certain statement against the Prime Minister of the country, and he was since he was produced in the competent court in Delhi, the court was directed by the Supreme Court to grant bail to Mr. Pawan Khera. I am sure that most of you are aware of it, owing to which, because there were a lot of news about the arrest of Mr. Pawan Khera. Moving on. The Delhi High Court has upheld the validity of the Agnipath scheme. The Delhi High Court said that the policy decisions with regard to national security are taken after careful consideration of socio-political scenario of the country along with socio-political scenario of the border countries. Further, a measured analysis is undertaken when it comes to application of schemes propounded by our country to the conditions in India. The court cannot, very, very important, the court cannot and should not delve into the proprieties of such policy decision and thus endanger one of the most important aspects of the basic structure doctrine, that is the principle of separation of power. Now, the Delhi High Court, while upholding the Agnipath scheme, says that it is a policy decision. The executive has the right to make certain policies. Now, it is not for the judiciary to enter into the domain of the executive. There is this very important thing called separation of power. The judiciary has its own separate rule, the legislature has its own separate rule, and the executive has its own separate rule. The judiciary should not embark upon the domain of the executive. That was the reason for upholding the Agnipath scheme by the Delhi High Court. The Delhi High Court further said that it appears that the government has been considering for a long time the possibility of creating an armed force which consists of more youthful, agile, and physical apt individual. Upon considering the options of expert bodies, defense personnel, and carefully studying the models adopted by other nations, it has decided to finally replace the prior model of recruitment with the recruitment envisaged by the Agnipath scheme. Considering that the stated objective of the government is neither discriminatory or mala fide or arbitrary, this court finds no reason to interfere with it. Now, the premise on which the Agnipath scheme was upheld was the simple reason that it is a policy decision. Now, policy decisions should not be interfered by the judiciary. The judiciary acts it. Now, there is a separation of power. The judiciary's role is different. The legislature's role is different. The executive role is different. One should not interfere with the exercise of other person's jurisdiction, right? So that was the reason on which the Delhi High Court upheld the Agnipath scheme. Expert opinions have also been sought in the Agnipath scheme, the impugned scheme, who have in fact suggested the revamping of the existing intake and retention scheme as well. Considering the fact that the laudable objective of maintaining national security is at the heart of the impugned scheme, that is the Agnipath scheme, this court does not find it arbitrary, capricious, or devoid of reason. So that is why the High Court, Delhi High Court, upheld this pretty scheme of Agnipath. Okay, moving on. BYJU'S Exam Prep brings to you a comprehensive course for CLAT 2024. In this particular course, we shall be providing you with 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests for CLAT and other law exams, along with video solutions, monthly e-magazine for current affairs, and the entire content is based on the extensive analysis of the previous years of CLAT question paper. Moving on. The Supreme Court of India has said that the National Green Tribunal has the power to execute its order. Now, if an order of the NGT is not followed, what does the NGT have? Does the NGT has the power to execute its order? Now, the Supreme Court has said that under Section 25 of the NGT Act, yes, the NGT, that is the National Green Tribunal, has the power to execute its order. Okay, It can deal with penalty for failure to comply with its order. So section 26 of the NGT Act deals with penalty for failure to comply with the orders of the tribunal. So the tribunal is entrusted with the power to ensure that its orders are complied with. Now, if an order is passed by the National Green Tribunal, if a particular order is passed by the National Green Tribunal, and if a party does not follow that order, does the National Green Tribunal has the power to execute its order? The Supreme Court says that yes, the National Green Tribunal has been empowered under section 26 of the NGT Act to execute its order. Okay, very important. Moving on, the Supreme Court, in a very remarkable judgment, has given a very great understanding about Article 14 of the Indian Constitution. The question before the court was whether it is justified that different pay is given to seemingly similar post. Now, two people are working in a particular place under the government of India. Now, can there be two different pay scale for them? The Supreme Court says yes, based on qualification. Now, for example, a carpenter. Suppose there is a carpenter with the government of India. Okay. Now, a carpenter, there might be a person who is not so qualified. There might be a person who is more qualified. So based on experience, there is always the principle for equal pay for equal work. But there can be a reasonable classification. There can be a reasonable classification insofar as this principle of equal pay for equal work is concerned. Let's see what the Supreme Court had to say. The principle of equal pay for equal work has no mechanical application in every case. Article 14 permits reasonable classification based on qualities or characteristics of person recruited or grouped together, as against those who were left out. Of course, the qualities or characteristics must have a reasonable relation to the object sought to be achieved. In service matter, merit or experience can be a proper basis for classification for the purpose of pay in order to promote efficiency in administration. Now, suppose a person has 10 years of experience, a person has 20 years of experience. Although they might be doing similar work, can a person who has 20 years of experience be given more salary than the person who has just 10 years of experience? The Supreme Court says yes, the government of India can. A higher pay scale to avoid stagnation or resultant frustration or lack of promotion avenues is also an acceptable reason for pay differentiation. The very fact that a person has not gone through the process of recruitment may itself, in certain cases, make a difference. If the education qualification are different, then also the doctrine may have no application. Even though persons may do the same work, the quality of the work may differ. When persons are selected by the selection committee on the basis of merit, with due regards to seniority, a higher pay scale granted to such persons who are evaluated by the competent authority cannot be challenged. A classification based on difference in educational qualification justifies the difference of pay scale. That's a very, very important judgment coming from the Supreme Court of India. Okay, it's a very, very important judgment coming from the Supreme Court of India relating to how Article 14 plays a very important role, but there can be certain exception to Article 14 also. Okay, moving on. The court further said that though the doctrine of equal pay for equal work is not an abstract doctrine, it is capable of being enforced in a court of law. The equal pay must be equal work of equal value. The equation of post and determination of pay scale in the primary function of the executive and not the judiciary. Courts therefore should not enter upon the task of job evaluation, which is generally left to the expert bodies like the Pay Commission, which undertakes rigorous exercise for job evaluation after taking into consideration several factors like nature of work, duties, accountability, responsibility attached to the post, the extent of the power conferred to the person holding a particular post, the promotional avenues, the statutory rules governing the conditions of service, the horizontal and vertical relatives which similar job post. It may be true that the nature of work involved in two posts, very, very important. It may be true that the nature of work involved in two posts may sometimes appear to be more or less similar. However, if the classification of post and determination of pay scale have reasonable nexus with the objective or purpose sought to be achieved, namely the efficiency of administration, Pay Commission would be justified in recommending and the state would be justified in prescribing different pay scale for a seemingly similar post. A higher pay scale to avoid stagnation or resultant frustration for lack of promotional avenues or frustration due to longer duration of promotional avenues is also an acceptable reason for pay differentiation. So, of course, two people might be working similar things, might have the same efficiency, but if somebody's qualification is more, if somebody's experience is more, then different pay scale can be granted to them. Furthermore, the Supreme Court said that the courts generally should not embark upon this particular issue of wage determination, because we have the Pay Commission of India, which puts a lot of time, which puts a lot of effort. It looks into various factors while determining pay scale of various posts across under the government of India as well as under the state government. Okay. Furthermore, the Supreme Court said that it is also well settled position that there could be more than one grade in a particular service. The classification of post and the determination of pay structure thus fall within the exclusive domain of the executive. Thus, the courts or tribunals cannot sit on appeal over the wisdom of the executive in prescribing certain pay structure and grade in a particular service. So that is exactly what the Supreme Court had to say in while determining this particular issue. Okay, I'm sure that you guys are understanding. Okay, fantastic, fantastic, fantastic. Okay, I'm moving on to the next important issue. The Supreme Court has constituted an expert committee to determine the Adani Hindenburg issue. Now, I'm sure all of you are aware of it. The opposition is asking for a joint parliamentary committee relating to the Adani Hindenburg report. Now, there is this Hindenburg report which says that Mr. Adani and company are into very wrong and unethical practices in the stock market. The Supreme Court, after hearing this particular issue, has appointed a committee which will be headed by former judge of the Supreme Court, Justice A.M. Sapre, Abhay Manohar Sapre, former judge of the Supreme Court. And there will be 5 other members, Mr. O.P. Bhatt, Mr. J.V. Devalkar, Mr. K.V. Kamath, Mr. Nandan Nilikini, and Advocate Somsekhar Sundaran. Somsekhar Sundaran, I'm sure you guys are aware of it. His name was given to be, his name has been recommended to be a judge of the Bombay High Court, but the government of India has put his file on hold. So Justice Abhay Manohar Sapre will be heading this particular committee, and there will be other 5 members, O.P. Bhatt, J.V. Devadhar, KV Kamath, Nandan Nilekani, and Somshekhar Sundaran. The committee has been asked to furnish its report within a period of 2 months. Now let's see, what is that committee to do? The committee is to provide an overall assessment of the situation, including relevant causal factors which have led to the volatility in the security markets. Now, after this Adani report, the Hindenburg report about Adani group of companies, the market, the securities market, there was huge amount of volatility. The market did crash. So they have to look into why did the market crash after the Hindenburg report. It also has to suggest measures to increase investor awareness. Why should investors not be aware of what is happening? Thirdly, this particular committee is to investigate whether there was regulatory framework in dealing with the alleged violation of law pertaining to the securities market in relation to the Adani group and other companies. And finally, it has to suggest measures to strengthen the statutory framework and regulatory framework and secure compliance with the existing framework for the protection of existing investors. So people do invest in the securities market. Now, the Securities and Exchange Board of India, the SEBI, is duty bound to take into account whether the protection of investors in the market. Now, after this Adani fiasco, what has happened is the fact that there was a report by Hindenburg. Now, this Hindenburg report made vast revelations about this Adani group of companies. It alleged that this particular group of companies were into a lot of illegal activities, and owing to which there was a crash in the stock market. And because of this, the Supreme Court has appointed a group of members, a committee which would be headed by former judge of the Supreme Court, Justice Abhay Manohar Sapre, to look into this, and they have to provide a report based on this. Is that clear, every one of you? Okay, beautiful. So guys, BYJU'S Exam Prep brings to you a scholarship test on 5th of March at 11 a.m. Get up to 90% scholarship on our preparation program. It is going to happen on 5th of March. Remember the date. So hurry up and register now for this scholarship test, wherein you can get up to 90% scholarship on our preparation program. So guys, if you like this session, do like this video, do subscribe to our YouTube channel, do follow us on our Instagram, do like our Facebook page, do join our Telegram channel. The URL is provided in the description box below, and do not forget to download the BYJU'S Exam Prep app. So guys, with this, we come to the end of this session. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Have a great weekend ahead. Bye-bye. Take care.